Justice Hecht, Chief?
I'm here.
All right. Well, let's go to item 3, suits affecting the parent-child relationship and out-of-time appeals in parental rights termination cases. Pam Barron and Bill Boyce, I believe, have got the helm on this one.
Yeah, thanks, Chip. And Bill Boyce was recently named vice chair of our subcommittee, and he is taking the lead on this for our subcommittee.
Great, thank you. Go ahead, Bill.
Thank you. So this proposal that we've outlined in the memo today revisits the topic that we have discussed at the last, at least the last 2 meetings. The overall inquiry is addressing circumstances that may lead to claims of ineffective assistance of counsel based on missed appellate deadlines in parental termination cases in circumstances when there is an entitlement to representation in connection with efforts by a governmental agency to terminate parental rights. If you want to see the roadmap, I'm not going to go through the whole background that's set out in the memo because we've done that a couple of times already. But if you want to follow the roadmap is issues for discussion on page 2 of the memo, and we're at stage 1A, which is dealing with a threshold issue. The threshold issue is showing or addressing either authority of an attorney to pursue an appeal, or a flip side of that, intent of a parent to pursue an appeal, as a threshold inquiry about whether there is a desire to move forward with an appeal that there is an entitlement to. What's new in this draft that you have in front of you are proposed revisions for discussion to Texas Rule of Civil Procedure 306. I want to give a hat tip to Roger Hughes because this proposal in large part stems from discussions that he initiated after our last meeting. But before we get to the particulars of a proposed rule, I want to put down a couple of qualifications. Number one, I don't know that there's really consensus among subcommittee members at this point that this is the ideal way to go. The subcommittee members may well weigh in with additional thoughts, but I think as in many situations, rather than have an abstract discussion, it's a lot easier to have a draft rule to talk about to flesh out the issues. And so that's the purpose of this draft right now. You'll recall from our prior meetings that there was substantial discussion around the issue of the difficulty of, in some circumstances, of determining whether there is a desire on the part of a parent whose rights have been terminated at the initiation of a government agency. There sometimes can be difficulty in determining whether there's a desire to appeal that for reasons that we discussed. The terminated parent may have never participated in the litigation, or the terminated parent may have come in and out of the litigation at different stages. A parent may be difficult to establish communication with because of a variety of factors such as homelessness or domestic abuse or substance dependency or some combination. And so there's not necessarily going to be a clear answer in all cases about whether there is a desire to pursue an appeal. That circumstance had led to our prior discussion about the issues around attorneys who are not sure if their clients want to appeal, pursuing a protective appeal or a phantom appeal that then leads to other consequences. The wheels of the appellate process are engaged, perhaps when it's not clear whether or not they really need to be because there's an intent to appeal, and that has consequences for courts and court reporters and such. So our prior meetings discussed potential mechanisms for trying to create a determination about whether or not there was an intent to appeal. And I think, I'm not sure that there was a universal consensus about the best way to go. I think there were some concerns about creating additional mechanisms or additional procedures. And we can flesh that out here shortly. But if you go to page 7 of the memo that was distributed for today's meeting, what you'll see is, and carrying over onto page 8, a showing of the current text of Texas Rule of Civil Procedure 306, and a draft discussion version of Rule 306. Prior discussions at the full committee meeting and the subcommittee meeting had identified Rule 306 as a potential area to place additional rules if that's the ultimate decision that we want to do that, because it already talks about requirements for a judgment in a suit for termination of the parent-child relationship. Rule 306 is not the only place in the rules that talks about that. And as Chief Justice Hecht mentioned, there's now additional guidance under Rule 277 for the types of jury findings that are needed to be made. We can have a discussion about where an appropriate rule should live if we want to continue down the path that this draft suggests. One of the topics that was discussed at the subcommittee was perhaps as part of this larger issue, we should look at putting all of the parental termination related rules together in one place, similar to the way that they're assembled in Part 7 of the Rules of Civil Procedure for other types of specialized court activities. We'll put that out there. We can come back to that later. Here's the point. Based on the discussion at the prior meetings and some concerns about the difficulties of determining whether or not there really is an intent and how to make that finding and when it should be made and so on and so forth, this draft rule that's contained at pages 7 and 8 of the memo attempts to realign the discussion around the existing statutory standards in the Texas Family Code for the duration of the attorney's representation and when that attorney ad litem is going to cease representation of the parent or the putative parent. And so the idea here is to have a mechanism that aligns with existing statutory standards, but also provides room to make the determinations that we've discussed previously about whether there is good cause to continue with the representation and thus the appeal. So if you look at page 7 under the draft rule 306, that first paragraph continues the second sentence of the existing rule. The subcommittee's thought was that the first sentence of existing rule 306 probably can be moved to rule 301 because it's generic to all types of cases and not necessarily specific to parental termination. But the draft rule picks up the second sentence of existing rule 306, and then the paragraphs 2A, B, and C cover circumstances under which the appointed attorney would continue or not continue with the representation. And within that, specifically under 2A, that contemplates a finding of good cause. That may be the place where further discussion can be made about whether or not there really is an intent to appeal, any difficulties in maintaining contact with the client, that sort of a thing. 2B points out or focuses on an area that I think that there was a significant amount of agreement with. I won't say universal or consensus, but I think a significant amount of agreement with in the prior discussions. And that was that sort of dividing the world into two. There are cases in which the putative father never appears in the case after citation, never participates, never evidences any circumstance or any evidence to indicate a wish to participate or contest termination. And I think there was probably some greater comfort level about having a default rule that said in that particular circumstance, it may be appropriate to say we're going to reach a conclusion that there's not a desire to pursue an appeal here and avoid a phantom appeal or a protective appeal in that circumstance. So that's what 2B is trying to get to, as distinguished from the other circumstance that was described where a parent involved in a parental termination proceeding may intermittently participate in the case, may disappear for a while and then reemerge, may participate at trial but then be unreachable after trial. Those sorts of situations where there was greater concern about having some sort of a default rule that would cut off rights. And so I think that's a sufficient preamble at this stage to open up the floor for further comments. And I guess I would suggest that to the extent that any of the subcommittee members want to elaborate on this introduction or point out anything that I've omitted, this would be the time to do it.
Thanks, Bill. I think Pam's got her hand up, and then Alex.
Yeah, let me just say we are suggesting changes to Rule 306. We realize those are not in the appellate rules. We're not trying to engage in a takeover here. We did coordinate with Frank Gilstrap's subcommittee, and they participated in our discussion on these changes. That's it.
Thank you, Alex.
I don't want to get into gender politics here, but it occurred to me as I was reading this, I understand why we say alleged father, but might it be better to say alleged parent? I don't know that I'm qualified to know whether that's appropriate or not, but I just raise it for Jackie or someone might want to check and see with all, gender is very fluid these days. So I don't know if fatherhood is fluid, but just want to flag that.
Thanks, Professor Albright. Justice Christopher, and then Frank.
So I was a little unclear what we're doing with respect to replacing by another attorney. Usually what happens now, you have a trial attorney in the parental termination cases, and then the court appoints someone else for the appeal. It's not the same lawyer generally that goes up for appeal. So was that intended to be there in section A?
You're talking about 2A?
2A.
Yes. Yes. So I think the short answer is yes, to just make it as broad as possible to provide to cover whatever might happen at the conclusion of the trial, either a termination of the trial attorney ad litem's participation and not going forward with the appeal, or termination of the attorney ad litem's participation at trial and going forward with the appeal with another attorney. Not trying to not limit it either way, but to provide a place in the rule where if a discussion is going to be had, does this terminated parent really want to appeal? That would be a place that would authorize it. Does that make sense?
I would be confused if I was a trial judge reading this.
Okay.
As to what it specifically addresses. I mean, if the idea is to capture only those cases where they don't want to appeal, I think the rule needs to be clearer. Because, otherwise we have this regular practice of, at least in Harris County, we always get a different lawyer, appointed lawyer for the appeal versus the trial. I mean, that's just a matter of course, for a number of reasons. The primary one is that you want the appellate lawyer to have an opportunity to say that the trial lawyer was ineffective. So, when you do the appointed process, you usually pick a different person for the appeal. So to me, I'd be confused about what we were doing here.
Okay.
Okay, Frank, then Roger, then Lisa.
First of all, with regard to Pam's comment, it was pretty easy to bring our subcommittee on board since we have considerable overlap with the appellate rules subcommittee, although the people that came on later were very helpful. With regard to the draft, I do have a comment on 2B. The idea, as I understood it, was that if say the father hasn't appeared at all, or maybe he's only appeared once briefly, then that's kind of a de minimis appearance. And so we're going to say under those circumstances, we can go ahead and conclude that there's good cause. But when I read the draft, it says in any manner, and a clever lawyer could read that just the opposite. There were 10 appearances and you only made 9, so you failed to appear in some manner. That's got to be clear.
Roger?
Two things. First, to address the thing about gender politics. I had a hand in suggesting this draft, and I chose that language to track the statutes when an ad litem must be appointed. And those are in 2 circumstances. One in which the government agency is attempting to terminate some parents' parental rights, or it's a paternity suit and they're trying to serve an alleged father. That's why the alleged father is in there. The second thing was, and this is a purely personal thing, I think trying to figure out what a parent who has very little contact with the attorney ad litem, or maybe none at all, trying to figure out what they want done in a given circumstance. Personally, this is my opinion, it's a legal fiction. And that if you appoint an appellate attorney, the only way they're going to feel safe is to march forward. So to me, I think to try to follow the statute, the question needs to be not does the attorney have authority to appeal. I think the question is whether there is good cause, yes or no, and that's a factual question, just to terminate the appointment of an attorney altogether. And that ends having to try to figure out a hypothetical issue as to whether the attorney, who may never have seen or met with the parent, or has only met 1 or 2 times and not recently, whether that attorney has authority to appeal. That's my 2 bits. Thank you.
Lisa? Lisa, if we can't hear you if you're talking.
Sorry about that. I promised myself I would not do that today. I'm unmuted now, but to Justice Christopher's comment, when I first read 2A, I thought it was a little bit cumbersome too, and maybe not clear. And maybe that's reason for us to all look at the language a little bit closer, but keep in mind that it says the judgment may state that an attorney ad litem appointed for a parent or alleged father is relieved or replaced by another attorney. So I think that the relieved or replace takes care of Harris County that always appoints a different appellate lawyer versus some of these small counties where they don't, that the trial court, they don't have an appellate wheel. They just have like a trial court CPS wheel and not an appellate wheel. So I think and I'll look forward to further discussion with you about it, Judge Christopher, but I just wanted to point that language out. And then Roger made the point about alleged father versus putative father. I always thought it was a putative father. Am I just making that up? Does the statute really talk about an alleged father?
I don't have the statute in front of me, so I can't remember the exact statutory language, but I was attempting to track the statutes and their language so that nothing would be missed or go astray.
Mm-hmm.
So if you go back to the statutes and they only use one term, then that's what we use.
As to your broader point, Roger, I think that Justice Boyd does a good job of laying out at the bottom of page 6, top of page 7, where what the real problem is meant to address, which is somebody disappears from a case for an amount of time. They might be imprisoned. They might be just going through, mental illness issues or so these, and I'm mostly speaking from experience of my partner being an appointed appellate attorney, where we don't, like, we are way past any, hopefully before we file our brief, we will have finally gotten in touch with the parent whose rights have been terminated, but there's all kinds of reasons it comes up: incarceration, other issues going on. Just they moved for a job and trying to get in touch with family members of like where they went for their job. Like, it's just harder than you can imagine. it's never as timely as you think it can be before we can even get on the phone call, like a phone call with the client. And I thought Justice Boyce did a really good job of outlining that for the committee. So the problem that we're trying to solve here.
Okay, thanks, Lisa. Pam?
Yeah, I think in response to Justice Christopher's comment, I see why she said that. And I'm wondering if this might fix it. If we changed A to say, or replaced by another attorney for purposes of appeal, and then add language in B and C that says, that makes clear that the attorney ad litem is discharged and no one will be appointed from there on for appeal. So we have, part A that says you're just relieved or replaced with an appellate attorney, and B and C have two situations where you're discharged without anyone else being appointed to continue the appeal. Would that work, Justice Christopher?
Justice Christopher?
Well, okay, so do we really have to have the judge put in good cause if they've decided to hire a different appellate attorney? As is just sort of the normal practice in Harris County, the trial attorney's out, the appellate attorney is in. I mean, do we have to have a finding of good cause all the time in the judgment to that effect? That's what I'm confused about. I mean,
Okay.
No, I think the first one says that the intent, and Justice Boyce can correct me if I'm wrong. The first one says that it's sort of the timing, like we want in the judgment whether we're going to relieve the trial court and or appoint a new one. The rest of them are meant to be the standard for when you're relieving them. But you might, a trial court, I don't know, some trial courts who do CPS cases tell me, and I can talk to Carlene about it, but I think B kind of only kicks in if you're gonna, like, if you've gotten some reason to believe that under Rule 12 or whatever standard we adopt, that the client doesn't want to pursue an appeal, right? And then at that matter, it's a standard. I don't know. It might be complicated because we're trying to do too much in one rule.
Right.
In other words, we're trying to determine, like, both the duration of an appointment and whether they have authority to pursue on. We're also trying to put the standard in there too. So we're trying to do the timing of who and when makes these decisions, and we're trying to do the standard for them, and we're doing it in the same rule, and that might be where the confusion is, Justice Boyce.
Mhm.
Pam?
Yeah, I don't think we need good cause in A, because good cause is in B and C.
Yeah, Justice Boyce, you tell me, was A meant to be that maybe I'm wrong about what you intended A to be. Is that the timing of it? It needs to happen. Maybe I'm just confused too. Sorry.
No, so the intent was to have kind of an overall provision that could be adapted to multiple circumstances. Maybe the attorney ad litem is relieved and not replaced. Maybe the attorney ad litem is relieved and replaced. I think, at least the way I was thinking about it, is 2A is kind of a catch-all to cover multiple circumstances. B and C are more specific to address the specifics that we talked about. For example, the alleged father who was served but never has appeared at all. And Lisa, just to follow up on your earlier question, I double checked the statute and it does refer to alleged father for
Okay,
whatever's that word. Now, that being said, maybe 2A is too much of a catch-all, and that's what's causing confusion, and there's going to be uncertainty about exactly what it authorizes or what it requires in the trial court. So if it's too much of a catch-all, then that can be granulated out some more.
Roger?
The reason the word good cause keeps appearing throughout the draft is that is a statutory and a case law requirement. The Supreme Court has basically said if the ad litem is going to be relieved, there needs to be a finding of good cause. And I think in one of the cases, and it's cited in the note, they said good cause is not going to be, I think the appeal is meritless. That's not good cause for relieving the attorney. That's good cause for a brief stating of the attorney's opinion, but not for relieving the attorney. So the reason why it was phrased that way was to give the judge a discretionary basis, which would be fact intensive or fact specific to the case, that for good cause. And that was all it was intended to do.
To that point, and in further criticism of A, that we may need to rework it, I don't think that replacing an ad litem requires good cause. So the way the rule is worded is that to relieve them, and I agree with Roger that that is the statutory standard, but appointing an appellate attorney in this case doesn't require good cause. In fact, it's a default that you would appoint them absent some acknowledgement by someone that the client doesn't want to appeal.
Okay. Justice Gray.
The issue, there's a lot of moving parts here, and I agree with whoever it was that said maybe we're trying to address too much in one place in the rules. But specifically with regard to replacing an attorney, there's a well-developed body of law in criminal cases that you cannot replace appointed counsel over the objection of the client, particularly prior to judgment. So the for good cause language in 2A may avoid a due process violation. Appointing an appellate specialist may in fact be the good cause you need, but there is a due process argument that once an attorney is appointed and the client is satisfied, you can't replace them just because you want somebody that's more cooperative or something to get into judgment is the problem.
Thank you, Justice Gray. Harvey Brown.
Well, it seems to me the relieved is the thing that is requiring the good cause, and replaced by another attorney may be that we need consent. So I would break those down into two separate things. I mean, I'd have a little I for relieved after stating a finding of good cause, or two little I replaced by another attorney with the consent of the parent or alleged father.
I think that's a great idea of breaking them out. The problem is that we're addressing a point where we don't necessarily know whether we're going, like, we don't know, we're assuming under this rule that we don't know where the parent is. So I don't know what you mean by consent. Maybe you mean unless objected to. It can't be consent though, because that assumes like an affirmative action by a client that we may not be able to get in touch with at this moment.
I think that's a good point. So maybe what you suggested, something of consent or some other language to take up the person who we can't reach.
Yep.
Justice Christopher.
Well,
Unmute.
I'm sorry, I was making an effort to sort of rewrite it. And to me, I mean, if we're going to put this in here, I would say the judgment must address the parent or alleged parent's appeal by one of the following. A, acknowledging the appointed ad litem will continue the appeal, or B, replacing the trial attorney with another attorney for the appeal, or C, where the parent or alleged parent has failed to appear, then you go into the good cause that you have in B and C. That, you know, there will be no appeal because the parent or alleged parent has failed to appear. I mean, let's make it clear what we're doing. There won't be an appeal at that point.
Roger. Roger, you need to unmute.
I just wanted to make 2 points. First, when I made my suggestions, I thought that the judgment ought to be the place where if an attorney is going to be relieved or an attorney will be replaced, that's where it be, that issue be resolved in the judgment so that everybody will know when and where that order is going to be, and that it not be some collateral order, which God only knows when it gets made. The second thing is, I was, when I read Judge Boyce's memo, I was really attracted to the idea of dealing with the phantom appeal by saying that there be a rule of an appellate procedure that incorporates Rule 12 and simply refers the matter back to the trial court to determine the attorney's, the ad litem attorney or the appointed counsel's authority to pursue the appeal. I think that's a good way to do it. And that's my 2 cents for it.
All right, Bill, back to you.
Okay, well, I've got the committee's guidance and can work with the subcommittee to reconfigure this proposal to try to make it more clear. I guess I would ask for the full committee's thoughts about whether Rule 306 is the place to do this, or do it somewhere else, or gather rules together. I have to say that I am persuaded by Roger's point that if we're going to try to have a clear place where everybody knows what to look to figure out what's going on and whether or not an attorney is going to continue and or there's going to be an appeal, steering the findings and the discussion to the judgment seems like a good place to do that, but there may be different thoughts about how to approach it.
Okay, Lisa and then Frank.
Okay, I just, first of all, Justice Boyce, I'm sorry that I didn't read this before this committee. I probably could have given you some advice before today, and I know you circulated it, and I apologize that I didn't get some comments to you before that. I really like Justice Christopher's idea of like breaking this down a little bit more simpler, and I think we do need to go back to the drafting table. I think one thing that struck me about her word choice, though, which I know she was just on the fly and was not committed to, when she says there will be no appeal if B or C, I don't think you can say it that Shelby, stop it. Sorry. It's my dog number 1. I don't think you can say it that bluntly, just because you still have discretion. A trial court, even if a father failed to appear in any manner, he might, I don't know. I can't think of the scenario, but I certainly would like for him to have some discretion based on the record and what he learned about the father or whoever, whatever parent. So I'm still want a little bit of discretion in there. I think we move into statutory drafting as legislators instead of just trying to interpret the family code if we go too far there. So that's just kind of a rule, just a thought as we move forward on redrafting. I kind of like the idea of the Roger suggestion about a Rule 12, but in the appellate court. Because things move so fast at the end of these trials, we may actually have more facts as the appeal is perfected, where someone could figure out how to show authority on appeal. The problem, of course, with that is that appellate courts, these can be fact intensive, and appellate courts aren't exactly the best place to resolve factual disputes. They could obviously abate it. But I think the reason why we've gone to the point of this needs to be made at the judgment stage and maybe before the client ever leaves the courtroom after the verdict is because of the problems, either getting the client after that moment or just who can really serve that fact-finding purpose.
Frank Gilstrap.
Chip, I think Bill had called for comments about placement, but apparently there's still some people that we need to, would like to talk about the provisions of the rule, which is much more important at this juncture than placement. So my comments don't have anything to do with the wording of the rule, and maybe you want to defer that.
No, I think go ahead now.
Okay. Well, you know, we don't talk about placement much, and you know, as you know, when we have a problem with the rules, we just try to fix the rule because we know that if we start tampering with other provisions, it can have unintended consequences. It's kind of like fixing a leak on a ship. You just fix the leak so you don't want it off the boat, but after a while, you fix leak after leak, and the ship tends to become unseaworthy. And I think we've kind of reached that point here with the rules 300. Originally, you know, as everybody's pointed out, the first sentence of Rule 306, which simply calls for the names of the parties against whom the judgment is rendered to be put in the judgment, is not a big deal, and it could easily be moved to Rule 301. But originally, Rule 306 was a big deal because it also required that you recite the findings of the jury and upon which the judgment of the court is based. And that was a big deal, but the court got rid of that in 1971. So we just had the first line of Rule 306, which was kind of a throwaway. But then in 2012, the court came back in and put this second sentence that we're struggling with about the recitations in a suit for termination. I don't know why the court put it there, but that's where it is. And now we're talking about making Rule 306 kind of a standalone rule dealing with this termination issue. That's not a bad idea, but it doesn't need to be at 306. It needs to be further back in the rules. And if you'll look at the rules, bear with me here. Rule in the 300s, Rule 300 through about, 307 or 308 are generalized rules that apply to every kind of case. Then when you get after that, you have very specialized rules that apply to different cases: foreclosures, suits against executors, appeal from justice court. The first one of those rules is a rule that is entitled in suits affecting the parent-child relationship. That's 308A. And when you read and said, well, that's a great place to put this rule, except when you read that rule, it has nothing to do with what we're talking about. It has to do with enforcing child support obligations you know, possession of child. And I don't know if that rule is still being used. I don't know anything about the area. It would be helpful to know what the current status of that rule is, but I think we need to take the rule that we're drafting and put it in 308B. It'll be fine there, and it'll stand alone. It'll be next door to another suit, another rule involving parent-child relationship. And I think Scott Stolley on our subcommittee said, well, this may be the time to go ahead and kick it over into the last part of the rules, where we have specialized rules like with trespass to try title, that type thing. I don't think the time has come yet, but certainly I think the rules involving judgment that touch on the parent-child relationship need to be together, and we don't need to put this rule back at the beginning of the rules where it's misplaced. That's all I have.
Thanks, Frank. Justice Gray.
This is a comment first back to where Lisa was talking about the need to have the ability to do the appeal even if you didn't participate in the trial. We've had the situation in Waco where the father never, and actually the mother as well, so it's gender neutral here, never showed up at any point during the trial. And the reality of it all didn't hit until the actual judgment. And so there may or may not have been problems about participation in the trial, but they may not even known about it until they wound up getting a copy of the judgment. And, you know, that's when it became real. That's when it became important to them. Sometimes it's where the child wound up that is the part that triggers the parent's reaction to the judgment. And so I agree with Lisa that there needs to be some way to preserve that ability to appeal, even if there was no participation during the course of the trial. And then second, I question whether or not we should be doing anything without Richard. You know, should we even get close to the family code without Richard's presence? So with that, I'll sign off.
All right. Scott Stolley.
Yeah, Chip. I want to echo a little bit of Frank's comments. In our subcommittee meeting, I mentioned that we meaning the court eventually might want to consider putting all of the rules related to the parent-child relationship in a different separate subpart toward the end of the rules of civil procedure. And toward the end there, we have separate subparts for various things like garnishments, attachments, injunctions, foreclosures, trespass to try title. And it seems like it would be a good idea to capture all of the rules relating to the parent-child relationship lawsuits in one place rather than having them scattered throughout the rules of civil procedure. You know, we're talking about one of the very fundamental constitutional rights here, the parent-child relationship. And we have other types of lawsuits that have their own subparts in the rules that are not nearly as important as the parent-child relationship. So I would urge that eventually the court create that separate subpart in the rules so that they're all in one place and not so hard to find. Thanks.
All right, thank you. No other hands are up, so I'll pitch it back to Bill.
Okay, I think that gives us the guidance we need to retool and come back.
All right, great. So we will, in Levi Benton's words, remand this one to the subcommittee and bring it back at our next meeting. Unless everybody is violently opposed, I'd like to work until for another hour until about 1:30. Would that be another hour? Yeah. Before we take our lunch break. The reason for that is not because I'm trying to starve everybody, but because Judge Mazant, while we've been in this meeting, set me for a TRO hearing this afternoon at 2. So that way I'll be able to hopefully get ready for the TRO, have the TRO, and be back with everybody by 2:30. So if there are no violent objections to that, we'll move on to the next rule, which is the parental leave continuance rule. And Professor Carlson and is the chair, Tom Riney is the vice chair, and Elaine, are you there?
I will chime in and say that she has asked me to take the lead today.
Okay, great. And I couldn't see who was speaking.
This is Kenan.
Okay, great. Fire away.
All right, so we have provided a memo for the committee's consideration. And in this memo, we have now presented a recommendation of the subcommittee for full committee consideration. To refresh everyone's memory, during the last meeting in which parental leave continuances were discussed, the subcommittee had for the committee just a draft, discussion draft. This is an actual recommendation based on input received from the full committee, both during the last meeting, which was on February 28th, 2020, and during a prior meeting on November 1, 2019. I'll just walk through some of the key points in the memo and then defer to other members of the subcommittee to make any further points that they think should be made before we have full discussion. So as noted in the memo, first paragraph, like I said earlier, we've had 2 meetings to discuss parental leave continuance and related issues. And I noticed in reading the transcript from the February 28, 2020 meeting that perhaps there was an error in the vote characterization that got carried over to this memo. So we'll have to go back and check, but from what I can tell from our last transcript, the full committee voted 20-1 in favor of proposing a rule addressing parental leave continuance on November 1, 2019. And over the course of time, what we've seen is a little bit of development in that when the State Bar Court Rules Committee was first looking at parental leave continuance, we had only the Florida rule and a local rule to kind of guide us. Since then, of course, we've had North Carolina come on board with a continuance rule for further guidance, and also some good language that's been carried over in part to the proposal before you today. Both the Florida and North Carolina rules are provided as attachments if you want to look at them. In addition, for your review, if you want to look at it, is the State Bar Court Rules Committee's proposed changes to Rule 253, the continuance rule. In addition, if you want to look at it again to refresh your memory, we've provided the Harris County Local Rule 11 that entitles the lead counsel to file a vacation letter that precludes a case from being set for trial and relieves counsel from engaging in pretrial proceedings during that time frame. Over the course of our discussion, we received input from the court, both during Supreme Court Advisory Committee meeting and also separately, to consider broadening the proposed continuance rule to extend not just to parental leave continuances, but also to situations set forth in the FMLA that, of course, extend beyond just the birth or adoption of a child. So that all of you can look at what's in the FMLA, we've also provided a copy of that as an attachment. So the proposal for consideration today begins on page 2 of the memo that's been provided to you. So we'll turn to that, and you can see at the top of page 2, you have the existing language of Rule 253 to kind of ground you. And then the subcommittee recommendation follows. So I'll cover some high points here, and again, leave it to the other subcommittee members to fill in any gaps they think need to be filled before we have a broad discussion. But I think a high point to make before we dive in is that there is this desire to kind of balance our personal needs, including parental needs and the need to care for our loved ones, with the need for efficient administration of justice. And so the challenge is striking the right balance in the proposal, and that's what the subcommittee has strived to do. So if you look at the rule that's proposed, subpart A is the part dealing with parental leave continuance specifically. As noted in footnote 1, we could refer to this as a secure leave period following North Carolina. But as of now, it's referred to as parental leave continuance because that is the subject matter at hand, specifically the birth of a child or the placement for adoption of a child. I know there was a lot of discussion during the last meeting about the scope for this rule and what it should cover. As of now, the recommendation is to include both trial settings and determination of summary judgment motions. Just to kind of give you all some additional background there, in North Carolina, there's application to proceedings and depositions. And I believe our legislative continuance rule here in Texas applies simply to trials. In this proposal, you'll see that 12 weeks is the presumptive maximum length for the parental leave continuance that may be taken within the 24 weeks after the birth or placement of a child for adoption. Unpacking that just a little bit, I believe that's what North Carolina does as well, and more specifically has the 12-week presumptive maximum length, but it's within this 24 weeks after birth or placement of a child for adoption. I'll insert just a personal note here that I think that 24-week period is good, in part because what it allows is for parental leave to be taken by a father, for example, perhaps not right after the birth of a child, but after the mother goes through a parental leave period. You'll see in the proposal there, paragraph A, still that upon a showing of good cause, the trial court may allow a longer time for the parental leave period. So that's just discretion accounting for variations that occur in our lives when we become parents, that we shouldn't try to imagine all those possibilities here as a committee or put them into the rule. There is then finally at the last part of subpart A, there an exclusion clause saying that the rule does not apply to cases arising under chapter 54, 83 through 85, or 262 of the Family Code. You'll see in footnotes explanations of what those chapters cover. And it also says that this wouldn't apply in involuntary civil commitment or guardianship proceedings. In footnote 6, you'll see that there's a recommendation of now, as of now, from the subcommittee to recommend presumptively mandatory parental leave application to expedited trials. But if we do that, we're going to need to amend Rule 169D2 to reflect the application of the proposed rule. Subpart A1 addresses timing for filing. I know there's been a lot of discussion about when the filing should occur. So you'll see here that it's at least 90 days before the date of commencement of parental leave period as to existing trial settings. And then for others, within 7 days of notice of a trial setting made less than 90 days before commencement of the secured leave period. Again, there's a sentence in here accounting for the fact that there's no way to predict the needs, timing, et cetera, for when we become parents and how that all unfolds. So last sentence of subpart A1 reads, but because of potential medical complications and the uncertainty of a child's birth or adoption date, the trial court must make reasonable exception to this requirement. So some discretion, but also mandate to make some reasonable exception. Turning the page to 3, you'll see that there is a requirement to support your motion for parental leave continuance, that you have an affidavit or an unsworn declaration confirming several things. I won't read all of those things, but you can see them all set forth there. One bracketed area for discussion is in 2B, where you have to show the continuance is not sought merely for delay. Bracketed language is in there, but to care for the child. That language, I believe, comes from the North Carolina rule. As you know, the default showing for these continuance motions is that you're moving so that justice may be done. So that's something to be discussed by the full committee, whether we should change the bracketed language or run with it. Then in 3, subpart A3, you see that the trial court must grant the continuance absent extraordinary circumstances stated in the trial court's order. Trial court shall enter a written order resetting the date of trial or determination of the summary judgment and adjust pending pretrial deadlines and scheduling order for the case, if any, to correspond with the new trial date. And then finally, it states, absent extraordinary circumstances, the trial court shall not set the case for trial, including summary judgment, during the designated leave period. Subpart B is intended to address other situations beyond this parental leave situation. I think most importantly for the committee's knowledge and discussion is to know that right now the subcommittee's proposal is that the FMLA parameters would be addressed in a comment that would correspond with the text of the Rule B. So if you turn finally to the last page of the memo 4, you'll see some standards for considering a motion for continuance under subsection B. What the trial court should consider is in that first sentence. And then in the next sentence, you see the FMLA standards there. So although discretionary, trial court should give serious consideration to granting a requested continuance when the attorney seeking the continuance, and then you have a list of 3 items which are coming straight from the FMLA. And then finally, in this comment, when granting a continuance under subsection B, trial court should consider using interim orders to minimize the harm caused by delay. Prompt reset is difficult to fit in the trial court schedule. The trial court should consider seeking the assistance of an assigned judge. I'll say my recollection, high level, of why the subcommittee decided to address FMLA in the comments is primarily that in the circumstances set forth, specifically 1, 2, 3 in the comment there coming from the FMLA, it's a little different, if you will, from the parental leave context. Most notably because for a parent who's a new parent, we all have this 3-month period where we know there is extreme dependency of the infant. And I think, as I mentioned before, it makes sense for us to consider that period where there is dependency needs that are more extreme than in other parts of a human's life. It's really more than 3 months. People say it's more about 6 months, which is why in my case, for example, my husband and I had a 6-month parental leave period starting with me and then going to him for 3 months. In these situations addressed by the FMLA, however, it can be a very long period of time potentially that comes into play. For example, I know in my own life, I've had a father-in-law who was in a hospice type situation for many, many months. Some people have had family members who were in hospice for years. And so these health conditions that may come up, or the need to care for a family member, it's harder to peg down how much time you need. The standards become much fuzzier. This conversation about whether you should make it mandatory or discretionary for the judge gets a lot more difficult and thorny, if you will. So ultimately, bottom line, the subcommittee felt like giving the trial court discretion made more sense and just providing this guidance in a comment as opposed to trying to address everything in the rule text proper. With that, I'll stop talking and turn it over to the subcommittee to address things that I've most likely inadvertently omitted.
All right, who wants to speak from the subcommittee? Okay, we're done. Just kidding. Just kidding. Well, if no subcommittee members want to talk, any comments about this proposal?
Chip, I'll say something. This area seems to me very, very difficult because I think there are weighty concerns on both sides. The concerns in favor of a mother especially, but also a father who had their career trajectory at stake and all that, and to be at the mercy of a trial court, that's a serious thing on one side, but the potential damage to the administration of the judicial system is also at stake. And so I think this is a very, very hard problem. I don't think that we can finish it. I just would be very surprised if we come up with something today that is, tight and good, and but it's just hard. And I think that the wisdom on this committee is the subcommittee would really love to have good discussion before we go back to the drawing board.
Yeah. Well said, Judge. Thank you. Frank?
Thank you, Chip. First of all, I oppose this. In prior meetings, I've opposed this rule, but you know that battle is over, and I think we've got to try to draft a good rule. And looking at the problems, I don't envy the subcommittee's position because there's some difficult issues here. But nevertheless, I'd like to look at Rule 253 as proposed and point out some issues. I think that's what we want. First of all, as I understand, we're going to put the triggering event is going to be a trial setting or a summary judgment. I understand summary judgment is a big deal now. More cases decided by summary judgment than by trial. But the language here, it says that in the first line, it says continuance of a trial, including the determination of a summary judgment. Well, that's different from the hearing. I mean, judges sometimes take summary judgment and sit on them till before trial. Then you go in and say, well, Judge, I want a continuance because you haven't determined the summary judgment. You're determining it right now, so I get a continuance. That needs to be clarified. At the end of that line, it says, in connection with the birth. Well, that's pretty vague. I'm not sure what connection with the birth means, but I would prefer because of something definite. And then then we say the birth or placement for adoption. And I'm not sure what the purpose of the rule's placement for. It would make sense just to say the birth or adoption of a child. You could read that to say, well, yeah, Judge, I'm placing a child for adoption in another court. It's not my child, but I'm the attorney doing it. Again, I don't see why we need the word placement for. And then we get into the real problem of, as somebody pointed out, gender politics. It's without placement, it would say birth or adoption of a child by an attorney movement, regardless of the movement's gender. Well, that makes sense where there's an adoption, but it doesn't make sense, literally speaking, where there's a birth, because the last time I read, fathers don't give birth. I know that's difficult to draw, but it right now, it doesn't make sense. Next issue, as I understand, we're talking about a minimum period which you have an absolute right for. And then the judge can extend it. But you, as I understood, you were going to get 12 weeks during the first 24 weeks. Well, it doesn't say that. It says 12 weeks is the presumptive maximum length. I'm not sure what that means. Okay, counsel, the presumption has been rebutted. You're getting 1 week. If we're going to give a guaranteed period of time, it needs to be specifically, and I don't think presumptive maximum length does it. Then moving down into 1, it says that, you know, in 1, we start talking about parental leave period as to the existing trial setting and within 7 days of the notice of the trial setting. But we don't mention summary judgment there. Then in the 4th line, we talk about secured leave period. Obviously a mistake because we haven't used that term to begin with. Finally, the last line of that sentence, the trial court must make a reasonable exception. Well, what is a reasonable exception that you must make? Let's see. Again, on page 3, we have in 2A, we don't have any mention of the summary judgment, and 2C, we do. And again, in 3, we get back to this language determination of the summary judgment, whatever that means. And finally, we say designated leave period. I'm not sure what that means. That's all I have.
All right, thanks. Justice Christopher.
I think I've said this before, I'm opposed to the 90-day time frame. And I think Frank was right in terms of the way that paragraph is written, in terms of what exactly does that mean in terms of reasonable exception. And then my other comment was in number 3, the trial court must grant the continuance absent extraordinary circumstances stated in the trial court's order. I assume that means they must grant the continuance if the movement has fully complied with number 2. I envision that there will be a debate over substantial responsibility for the preparation or presentation of the case. And so the question, you know, if someone is opposing it, if someone files their motion, the other side's opposing it and says, you know, I've never seen this lawyer on the case. How on earth do they have substantial responsibility for the preparation or presentation of the case? And I assume that the extraordinary circumstances wouldn't apply there. I mean, if they don't meet the requirements of the rule, they don't get the continuance, right? That's my thoughts.
Okay. Judge Estevez.
Yeah, I was listening to Frank's comments regarding placement for adoption of a child, and I think it'd be very helpful to have a definition of what placement for adoption of a child is. My brother adopted a child from Taiwan, so they went to Taiwan, they picked up a baby, and they definitely need this leave. I was a foster parent, you know, and so I have step-parent adoptions where the child's lived with them for 5 years and they are, maybe they're not placed for adoption, but they get adopted after living there 5 years. They're going to, the child's going to school for the next few years, you know, and the next day. So are we talking about any type of adoption where the mother didn't adopt the child, but the father adopted the child? Are we talking about only when the placement is a baby where it will have higher needs? Because if we place a child for adoption and the child is 10 and we're in a school year and we don't have COVID, then that means that child's going to school or any other pandemic. So I don't know if our intent is really to have it that broad, and maybe it is because we want everybody to have that right to have that time with the child, but if the kid is the age for school, then that child's not going to be home with that parent. So it could be used, you know, without having to show any type of good cause. They just get a vacation for a few weeks and there's nothing you can do about it. And I'm not suggesting people would do that. I just think that it'd be helpful to just have a definition. I think everybody knows what a birth is, but I don't know that placement for adoption is the same in every circumstance.
Great, thank you. Any other comments?
Chip?
Yeah, Judge People.
Okay. The Harris County vacation rule is something that came to us at the last minute. At least I didn't see it until just a few days ago. And I'd like to ask the Houston lawyers how that works, and if it gets abused, is it hard for judges to administer? It's elegant almost in its simplicity and its clarity, but I can see a lot of, I mean, there could be games played there. What's the experience with that?
All right.
Those of you who've lived with it. Well, I know the time period, the maximum is 4 weeks. That's a big difference, but there are some similarities, and I'd like to know how it works.
It's you have a deadline to submit it, but it's a process. You just pick your 4 weeks that you don't want to be called to trial. And you don't have to have a reason for it. And you obviously don't have to go on vacation during those weeks, but you're able to block trial settings during that time. And what ends up happening, at least in my experience, is very few cases go to trial in the summer because of the vacation letters.
Justice Christopher.
Yes, especially if it's a if it's a multi-party case. I think sometimes the lawyers get together and block out the whole summer by putting down dates, to block it off as a way to give themselves a continuance without actually asking for the continuance. But from my perspective as a trial judge, we always had plenty of cases that wanted to go to trial, and if people wanted to block it out, fine. The number of trials tends to go down in the summertime, just because people are on vacation. They, want to do this or that. But there is definitely gamesmanship involved in it, but it didn't really seem to stop the wheels of justice by allowing it.
Chip, this is Rusty on audio, so I can't raise a hand. But my experience has been, to answer the question, it's worked pretty well, really. We have a deadline to get those submissions in. I just had a recent situation to amend mine by a week or two and was able to do it, but it wasn't in connection with any trials, in connection with the trip. Actually, I think most trial lawyers in Houston like the system, and I quite frankly have never heard it. It's so ingrained, we never hear anybody complaining about it. Let me put it that way. And it's not something that you could do like the legislative continuance, which was always so abused, where you could do it at the last minute. It's something that you've got to apply for with looking ahead. And 4 quarters, you can do it throughout the year, but you're limited to the 30 days a year. I think if you polled most lawyers in Houston, they think it works fine.
Thanks, Rusty. And everybody should be aware that Rusty was recently voted by somebody as a legal legend in Texas.
Yeah, well, that is. Anyway, I would ignore I would ignore Chip on these matters and get back to the rule, please.
Absolutely true. Levi.
Yeah. So, David, one, I'm kind of shocked to hear that Bexar County doesn't have such a rule. And I would add to the things that have been said, Chip Babcock, for example, could have 10 cases pending. And let's say he has a case against Jim Perdue that he knows he's going to lose. He could assert his vacation letter in the case against Jim, but not assert his vacation letter in another case pending the same week. It's his right. It's an absolute right to assert. And I've never known of a Harris County trial court judge to disregard a vacation letter.
Robert.
I wanted to respond to Judge Esteves' comments about needing more definitions. I think that there are so many different possibilities that are in the area that it probably would be counterproductive to try to define all the potential situations with adoption or even birth. You could have a surrogacy, a same-sex couple that is working through surrogacy or other situations, so that it would be very difficult to line out all the possible situations. And rather, I think the court just needs to evaluate the motion under its own terms to decide whether it fits the rule and is appropriate.
Thank you, Frank. You'd have to unmute, Frank.
Frank is just saying how much he loves the rule.
I know, right. Are we ready to talk about Part B? Have we verged over into Part B of the rule yet?
Well, maybe we slopped over a little bit, but just go ahead and say what you want to say, and then Harvey and Jim Perdue will weigh in.
The comments that I've heard all seem to relate to the old adage that Harris County is uninhabitable in summer. But aside from that, B, we talk about discretion upon good cause. I'm not sure what that means. And then we have this enormous comment. I understand, and I don't know where it came from, but you know, the idea has been for years not to make the rules in the comments, and here we have this you know, one of the longest comments I think in the rules about this, and moreover, these comments only apply to Part B. Well, in Part A, I thought that the judge had discretion to grant more than 12 weeks. Why wouldn't some of these things apply to Part A? The problem is that you know, there really isn't any need for B. The existing rule has always handled, we've always handled it under the existing rule just fine. But to kind of save face, we have to put B in there to show that this is not some kind of deal just for lawyers. I really question whether B in the comment is a wise choice.
Thank you, Frank. Harvey.
Well, I think the comment is generally very good and a good idea for the outlier judges who don't take these things into consideration. That'll help somebody get a continuance with that. But I want to talk a little bit about subpart 2E, the language in the brackets, quote, but to care for the child. I think not only that be in there, but I think we should have an additional requirement. I could just see this being abused potentially by people who are working regular, doing their regular job, and are going to continue to work their regular job, but just want to get off for the trial setting. So I would not only require them to say that they're doing this to care for the child, but that they are not, and I don't know exactly how to word it, but basically are not working their regular job and work hours, that they're actually taking leave from their normal job duties.
What section was that, Harvey?
I'll say what you're on mute. I think though you're referring to A to E, correct?
Yes, 2E, it's on page 3, it's indented, cap E.
Okay, Jim Perdue.
Well, so I'll dovetail a bit with what Harvey was saying and go back. So Judge Peoples, part of the elegance of the vacation letter rule for Harris County, which has been abused and does eviscerate trial dockets in July and August. And Frank, it is unlivable here in July and August, but we do have air conditioning and tunnels, and we make do. But the self-constraining aspect to my personal experience of the vacation rule is that you're talking about 4 weeks. So whether it be invoked, you know, outside the summer or all in the summer, there is a self-limitation on a 4-week continuance that has taken away trial settings, no doubt, and has frustrated the heck out of me because I have seen multi-defendant cases where it's used. But you do eventually get the train back on the tracks, and it can't take things over. This rule is talking about a lot longer period of time. And I understand in concept the idea and the pleasantness of tracking along with family medical leave, But when you start talking about blocking 3 months, that is a different event altogether on a litigation timeline. And I'm trying to catch up on the language that ended up being the amended or final language in Florida, and understanding how they came back on this a little bit. But the odd thing that it seems to me the subcommittee is balancing is this idea of advance notice that you're going to take it versus the events that qualify for taking it, which sometimes don't give you 90 days advance notice, but the parties need some advance notice. And then language that, this is as to Judge Brown's point, this thing has got to get to balance somehow the idea that somebody truly is unable to perform in the capacity of either lead or, substantial role counsel because of this responsibility, which is honored in the law. But at the same time, you have the ethical responsibility that if you've undertaken to represent a client in a piece of litigation, you have to be able to do that. And it strikes me that if you had a conflict that was taking you away from your ability to represent your client for, 3, 4, 5, 6 months, I don't know how in the law you build in the idea that then the lawyer has not crossed over into an area that kind of cessation of activity is not representation of that client. So I'm trying to balance, not necessarily from an adverse counsel perspective on the rule, but if you take Judge Brown's point, which I think is important, which you truly have a conflict that prevents you from serving in the role, then how is it that you stay maintained as lead counsel for that client for 6 months when the case just is allowed to sit there? That's a real tension that I'm not sure I'm seeing how it's balanced through in the language of this. And I don't know how they solved it in North Carolina and Florida, because I'm not as well versed in the materials that you sent. My apologies for that.
Justice Christopher.
Yes, I disagree with Harvey that we should include but to care for the child, because I do think that even if you're going to the office and working, it's very different from being in trial, which, as you know, is a 15-hour day, not an 8-hour day. And having my husband home when I was on maternity leave at 5 o'clock was a lot better than having him home at 10 o'clock. And I think the men ought to be able to take that leave. With respect to Jim's concerns, the rule does require that the client has consented to the continuance. And I do understand that under the FMLA, and we've seen this at the appellate court, someone will write in and say, I've got cancer, I can't get my brief done. And, you give them 3 months, and then they want, another 6 months, they want another 9 months, and at some point you have to say to them, are you actually representing your, client at this point? Does your client really understand that, your appeal or your trial has been abated and unable to move forward? So to me, the client's consent is important with respect to longer than 12 weeks. Those are my thoughts.
Thank you, Justice Christopher. Justice Gray.
I won't repeat what I've said before about why the rule focused on the family continuance is such a small part of what we need to be addressing. I think if we need the rule at all, it's a judge training problem that really can't be solved by a rule. I would strongly suggest that we bolster the range of considerations that are discussed in B and have only the B part of the rule and require judicial education on the issue like we do for ethics and family violence. I mean, there are so many factors that you as a trial judge need to consider when you're granting a continuance on the eve of trial that affects so many people's lives besides just the lawyers, the witnesses, the other litigants that are going to be forced to trial if you don't go to trial. I mean, there's just a lot of moving parts in a situation like this that it's almost impossible to write a rule that is going to capture when a trial court abuses his discretion in granting or denying a rule or granting or denying a continuance. And these are going to come to us in mandamus proceedings because a trial court did or did not grant them. And so what I'm asking is that you just make it clear enough that I can either know I'm going to grant it or know I'm going to deny the mandamus and have a leg to stand on, because they're coming to us if they're granted or denied, and we're going to need some help.
Okay. Thank you, Judge. Any more comments about this subcommittee report or the proposed rule? Anybody else have any comments? Lisa Hobbs.
Okay. You know, as we're listening to everybody's comments, I think we're both, I think some people want, and to Justice Gray's comment, like, be very clear. And I think when you try to write into a rule, just like trial court discretion, right? Like, we want to maintain some kind of discretion, but we're giving these parameters. It's just trial court discretion, and maybe Justice Hecht will agree with me. It's like, I know it when it's abused. I don't know, like, it's just, it's hard to say. And I just feel like some of the comments, just to sum up, are both that we're doing too much and we're not doing enough. And the reason why that we're having these views is because it's hard to put into a rule what is the parameters of discretion when it comes to the uncertainty of medical conditions and leave and how babies are born and how mothers are responding to it and how adoptions come about and all these things. And I just wonder if, and I agree with the spirit of allowing a continuance for parental leave, but I wonder if there's a more streamlined way to go about it, possibly even just a comment to the continuance rule. And I'll leave it at that.
Thank you, Lisa. Commissioner Sullivan.
Yes, sir. First, I just want to thank Kennan for the job she did in laying this proposed rule out. I thought she did a great job. And reference a comment or two made earlier. One, Judge Peoples made the really important one, and that is issues like these are hard. They really are. It's the intersection between these kinds of important considerations and the procedural issues that we all have to balance. And in that sense, Frank's much earlier comment weighs on me a little bit here. He was talking about, you're trying to fix holes in a boat, and you realize that at some point you need to look at the entire boat and fixing it more holistically. And I do think it's something that we're going to have to take a look at. I do think that while I suspect virtually everybody is in agreement that we should accommodate parental leave, such as we are discussing today, there is a tendency, I think, particularly for a group like ours, to underestimate the damage that is caused by procedural uncertainty, delay, and excess cost that our system can produce. Those are burdens that disproportionately, I think, fall on clients and less so on lawyers and judges. So I think at some point, we really do need to step back and take a more holistic look. I think it's always difficult when we look at these in a granular fashion. As I say, I think almost everybody is in favor conceptually of parental leave and the accommodations that ought to be made for somebody. But you can also create a list of other situations where you would probably produce a similar vote. I've seen in the courtroom that the issue come up in terms of the death of a parent. I remember one case vividly in terms of someone asking for an accommodation and actually not getting much of any accommodation. What about, God forbid, the death of a child? That would be extraordinary, and the list can go on. I guess the point is that there are a lot of really difficult circumstances, and you do wonder to what extent you want to create inflexible rules around those. And I finish with one other point back to Chief Justice Hecht's earliest comments, and that is he recited, I think, the numbers for criminal and civil trials in the state last year, 4,500 and 1,200, I think, is what he referenced. And when you consider the size of the state and the number of cases filed, I think what we need to acknowledge is that number is extraordinarily low. And we need to acknowledge there are reasons for that, and for what increasingly I think is a problem in confidence attached to the system in terms of delay, cost, certainty, and at some point we're going to have to address it. If we do this, if we deal with these sorts of procedural issues in isolation and in the abstract, we do run a risk of simply exacerbating some of the issues. But again, I say that I'm in favor of accommodations for parental leave. I suspect virtually everybody on the committee is.
Thank you, Commissioner. Chief Justice Hecht and then Roger.
Just to fill in on the number of jury trials, civil jury trials are and have been for years a little over 0.4% of the cases filed. And on the criminal side, it's about it runs a little less than 2%, about 1.5 or 6. Sometimes it goes up and down a little bit.
Roger.
Well, I'll echo what I said at the last meeting. This is an idea whose time has come. We're going to have to figure out how to integrate this into it. And if there's a direction to go, my personal favorite is that we have a minimum amount of time off if the application meets the standards. And I think it's part of the reason it's hard is that there's just a lot of circumstances that go on around pregnancy or adoption that until the last decade or so, we didn't have to deal with. Well, now we do. And it may require acquiring information, but I think we're going to have to make that accommodation. So that's my 2 cents worth. Thank you.
Thank you, Roger. You all probably thought I was out of my mind when I said we were going to have to work until 1:30. I was off on my time zones. Sorry, I'm on the Eastern time zone. So we can take a break for lunch. The parental leave continuance rule, unless the chief or Justice Bland think that, or Jackie would think we would benefit from more discussion about it, we'll submit that to the court. So speak now or forever hold your peace on that. And I don't think, since we're all, I think, within reasonable distance of food, that we maybe need an hour. And since we can't congregate with each other and chit chat, maybe we could come back at 1 o'clock. Would that be satisfactory to everybody? If anybody's against that, raise your hand electronically. I see no hands raised. So we'll be adjourned until 1 p.m. And everybody will have to dial back into the meeting at that point. Thanks, everybody.
Thank you, Chip.
Chip, you can